let's talk about what employers need to think about when you are considering hiring an H-1B worker. How do you know if this is somebody that you're going to be able to employ long term? What do you need to know about their green card history of their process? Well, there are a lot of H-1B workers that are looking for jobs right now. There have been some companies with major layoffs, and that has put a lot of really talented H-1B workers into the job market right now. Question I get a lot is, gosh, why are so many of them Indian? The reason for that is multiple reasons, but the main one is that Indians wait longer than anybody else in the world to get employment-based green cards. So green cards are given out in, I think of it as a pie, and everybody can only have every country of birth can only have a small slice. And so India's slice is the same size as, Lesotho slice or any other tiny country, Mozambique slice or Luxembourg slice. It's a little small slice. It's not big enough for how many people want it. So a lot of people do the first two steps to get a green card, and then they wait in a very long backlog. So that means they are just continuing their H-1B status. So it's very normal that you would encounter workers in the job market who have H-1B status that they've had for more than 6 years, even though 6 years is supposed to be the maximum you can have an H-1B. And I think historically when it was set up, the idea was, hey, by the end of 6 years, you'd have a green card. If you started, you'd get to the end and you'd have it. That has not been the case for many years because it's just a really high demand and we don't adjust how many spots are available. So we're only giving out about 150,000 employment-based green cards a year, regardless of how many people are trying to get them. There is no limit on how many international students we have. There is no limit on how many people can start a labor certification or get an I-140 petition approved, but there is a limit on how many people can get a green card. So there are a lot of people clogging up, or should I say a lot of people are clogged in the system right now, and they're H-1B workers. So there are H-1B workers in the pool right now who are in their 40s, and they've been doing this since they finished graduate school. These are people who, in some cases, are really high-level, specialized, valuable, highly paid professionals, but they don't have green cards yet. That is not because they are not trying or because they don't deserve them. It is really a question of supply and demand, and the fact that so much of our employment-based green card system is not based on it's not a meritocracy, like we're going to pick the best people. Labor certification is about making sure there was no adequate American who could have substituted. So everybody who's waiting for a green card who's had a labor certification has just shown that at the time that their company looked, they didn't find a U.S. worker that they could have hired instead of them for that specific position. It doesn't mean that the H-1B worker was the absolute best person available. It just means there actually was not even a minimally qualified American who could have had the job instead. So when you are talking to an H-1B candidate, you're probably asking yourself, gosh, can the company do this? Is this going to work for our timing? So let's talk about timing first. When you have an H-1B candidate that you extend a job offer to, note that you can't start them in the new job until their petition is filed. You will have to file a change of employer petition to USCIS. Don't have to wait for it to get approved, but a lot of times the company and the worker prefer to wait for it to be approved. When they don't prefer for it to be approved is often if the H-1B worker is already currently done with their old job, they were terminated, then they're probably going to be really eager to get started as soon as possible, and the employer will probably feel the same way. If they have an H-1B job already, the reason they may not want to jump to your job until their petition is approved is because they want to make sure it's going to get approved. And they may want to make sure it gets approved and then give notice and then work out their notice period before they come. That's all perfectly allowed. Um, so when you're thinking about their timing, it's important to ask them, do you want to start immediately as soon as possible, or are you planning to do a notice period? You put a requested start date on that petition, and if they have it started by that date, it's no big deal. They don't have to. If their petition um, is approved before the start date, then you do have to think about it. So if you thought, okay, they want to give notice after approval and we're going to use premium and, let's just make it like 2 months out. But then it goes through quickly and you have a petition approved quickly and then they give notice and their employer says, okay, get out right now, don't work a notice period. Then you got a position, you're in a position where that H-1B worker might be just sitting around waiting for the start date. So most employers do choose to pick a start date that's like maybe even earlier than they actually intend. But just in case the stars align and everything goes fast, they don't want to have to wait for that petition start date to come around. I always make sure that when we're setting an aggressively early start date, that my client understands that we're not guaranteeing that the petition is going to be approved by then. We're just asking for this date so that if it is so that if the petition's filed on time and your employee to be is ready, they can start. So I would say talk to your lawyer. They can give you the idea of how long the H-1B is going to take, but it's not a super long process. Once you give your lawyer the go-ahead, say we hired an H-1B worker, he said yes, or she, they're going to ask you, they're going to do their regular intake. They're going to need to know all the details about the offered job. Where is it located? What are the duties? How much is it going to pay? Everything they're going to need to know for the petition. And then there is a mandatory step that you're going to need to build 8 days in for, which is they're going to ask the Department of Labor to approve the LCA, the labor certification, the labor condition application, excuse me. Now, there are 2 things that LCA stands for in business immigration. It's really annoying. Both of them are things from the DOL. There's the labor certification application, which is a PERM, which is part of the green card process. And then there's the labor condition application, which is only for H-1Bs, E-3s, and H-1B ones. And that's non-immigrant statuses where you tell the Department of Labor, hey, we're going to employ a person or a number of people in this occupation, this level of seniority, and we're going to pay them this pay range. Is that okay? And they say yes. It takes them 8 days to say yes. You cannot file the H-1B petition until that LCA is approved because it's got to be included in the petition filing. So always going to have to wait that bit of time, no matter how long no matter how urgently you want the worker to start, that LCA has to be approved before you can file. Once you do file, you got to wait until the petition is received. So you can wait until you get the receipt notice. You can wait until, if you did premium processing, then the attorney's going to get an email that confirms receipt of the petition. You can use a delivery service like UPS or FedEx and use as your placeholder that they delivered the package. If you have any of those, your worker can start. Or you can wait until the petition is approved. If you are going to do the I-9 based on not having the approval in hand, look at the I-9 handbook that the government maintains online and make sure you're doing it exactly right.